I want to first thank the chairman and the ranking member for allowing me to ask questions. Mr. Harbeck, I am not a securities attorney. I am a doctor. So your knowledge greatly exceeds mine, and if I say something stupid, it won't be the first time, won't be the last, and please forgive me. That said, let me first ask, was there a settlement offered by SIPC to SEC on behalf of the Stanford victims?
There were settlement discussions, yes, Doctor.
And was one offered?
We made an offer, but I would hasten to add that I won't go into the details on that.
That's fine. That's fine. But the fact that you offered, even though you categorically deny the rationale for in your testimony, gives me a little bit of pause regarding your testimony. Secondly, let me ask you this. It seems as if you have two objections to SIPC expanding coverage. One, that SIPC does not cover losses of an investment, and two, the custody issue. So let me take the first. You quoted a court case earlier in your reply to Mr. Green. Clearly, you're an attorney. You defer to court. Do you disagree with the Fifth Circuit Court, which found that a Ponzi scheme is, as of a matter of law, insolvent from the inception, that the value is fictitious, there is no value to lose because the value is not there at its inception? Do you disagree with the Fifth Circuit?
The fact that it is insolvent from the initial moment does not detract from the fact that the instrument received by the Stanford people was a real certificate of deposit issued by a real bank in a real country that is in a real receivership.
It is a piece of paper, all agree with that, but whether or not the value is real or fictitious seems to be the point. And the fact that it's insolvent at inception suggests that the value is fictitious. And I will just make that point, and you can hash that out in court. But
the other thing I'd like to say, Doctor, is this matter is in litigation.
I understand that, but on the other hand, I think
I'm constrained by that.
Your testimony, written and spoken, really went after this case as if it were in case, and I think it's important on behalf of the victims to make the counter-argument, if you will. So if the first point is that indeed the value is fictitious and there may not have been value to lose, let's move to the second regarding custody. Again, knowing that you're an attorney and that you've previously quoted court cases in reply to Mr. Green, you spoke earlier about how you would have to fold in these different entities in the Stanford Financial Group to, if you will, give the Stanford victims standing. And yet there is a U.S. District Court for North Texas that says that the Stanford International Bank and Stanford Financial should be collapsed together, indeed, that they should be folded. And it is, again, a fiction to pretend that they are different. Now, that effect, my understanding, again, I'm a gastroenterologist, what do I know? Although I feel like I'm kind of in the suite right now. That would not give them standing as a customer?
For a wide variety of legal reasons, the answer is no.
Okay.
Among other things, the independence of the entity in Aruba has been recognized in several other countries, who have not turned over assets to the receiver in Texas.
Now, let me just point out, though, that the Stanford Group Company was a broker-dealer registered with the Commission and a SIPC member, that both that and the Stanford International Bank Limited were wholly owned and directed by Stanford, that the Stanford Financial Group was a brand name under which SGC, SIBL, and others operated to give credibility to SIBL, and that domestic clients purchasing Stanford International Bank Limited CDs dealt substantially, if not exclusively, with Stanford Group Company brokers, and that some SGCs, if you will, account holders, received consolidated statements from SGC regarding their Stanford International Bank loan investment. I could go on, but I think I'm making the point. It does seem as if there is a case for them to be folded together. As the North Texas District Court suggests, this would be the one to do so. Let me just kind of go on for a couple other things, because I'm almost out of time. I apologize. I have to admit, you give the hypothetical of, well, we have a salesman that says, go ahead and invest in the Ponzi scheme and you will be covered. And I have to say that there isn't a victim yet who I've learned would have invested in this Ponzi scheme should they have known it was a Ponzi scheme. Now, I will just frankly dispute that. And the idea that somehow, don't worry, you give your $500K to us and we'll cover it on the backside, forget the fact that you've lost the investment value over the period of time it's with them. I'll just make that point. But one last thing, since there was a settlement offer And since there has been discussion as to the amount of money it would cost for such a settlement, can you give us the cash figure that SIPC thought would be involved in such a settlement?
No, sir, I will not.
Okay,
That
I
is a
appreciate
matter
that.
in litigation.
But I will presume because you are fiduciary agents, it would not have been one that would have broken the bank, and I think that point needs to be made. You've been generous with your time. I yield back. Thank you.
I thank the gentleman. All